Hello, I'm Bella Webb and I practice as a barrister dealing with clinical negligence claims at Old Square Chambers. I'm going to talk to you today about fatal accident claims, but not the run-of-the-mill stuff, the tricky bits that have us all tearing our hair out. I know that everyone watching will be very familiar with the day-to-day issues with these cases, such as the distinction between the Law Reform Miscellaneous Provisions Act and the Fatal Accidents Act. So I'm going to take all of the usual stuff as read and look at a few select points that are a bit more nuanced. I'm not saying I've got the answers, but they are very interesting to debate and hopefully they'll throw up some food for thought. Let's get started then. Slide 1 is how lots of us lawyers feel about the fatal accident legislation and the management of these claims. So we're going to try and demystify some of it. As I've already noted, there is a distinction between the Law Reform Miscellaneous Provisions Act and the Fatal Accidents Act, which you all already know. And in essence, these two provisions act as the divider between pre and post-death. The Law Reform Miscellaneous Provisions Act passes the deceased's cause of action to their estate for pre-death events, and the Fatal Accidents Act relates to post-death dependency. And essentially what we need to bear in mind in all of these tricky situations is that the law relating to fatal accidents is entirely a creature of statute. So the Fatal Accidents Act in particular, as you'll see there on the slide, it is a much disliked and often arbitrary bit of legislation, and it's been subject to criticism for years. And sadly, there isn't a whole lot of evidence of change on the horizon in spite of attempts to do so by the Law Commission. So as a result, claims under these provisions allow for a very broad application of principle to allow the court's sympathies to shine through. And so long as the judge remains within a very wide range of a reasonable approach, their decisions are generally unlikely to be interfered with on appeal.